I call the member for Balmain.
Thank you, Madam Temporary Speaker. And I rise this evening to address the Education Amendment Not-for-Profit Non-Government Schools Funding Bill 2014 on behalf of the Greens. Madam Temporary Speaker, we support this bill, and I'd just like to take a few minutes, understanding that it's late, to address a little bit of the history and the reasons why we're supporting the bill. As we know, there's already in the Education Act a provision that bans non-government schools from using private funding for profit, which was introduced in 2006 by the former Labor government. We Greens played an important role in lobbying and encouraging the former Labor government to introduce these changes when it emerged that ABC Learning, a private company, had plans to set up a private school in the Hunter Valley, in fact, in 2006. At the time, we argued that the $730 million per annum state government public funding of non-government schools meant, of course, these were high stakes, and now, a few short years later, this figure is now at $1 billion per annum. The legislation, however, moved by the former government was not comprehensive and left two gaping loopholes that the Greens identified at the time and sought to resolve. I wanted to quote, if I can, from the Sydney Morning Herald, the 24th of June 2006, where Dr John Kay, who was not in Parliament at the time but was the party's education spokesperson, said, and I quote, "The proposed legislation allows unrestricted payments to members of the governing body without affecting the school's abilities to receive public funding. All ABC Learning needs to do is put themselves or a shelf company on the school's governing body and pay themselves a massive fee. Public money will inevitably end up as corporate profits unless the New South Wales government has the courage to change their legislation." The government, however, not to anyone's surprise, voted against those amendments to fix those loopholes. So now, these years later, we have a coalition government who are trying to fix them, and we support them in doing so. The community, and I think it's clear to everyone in this House, but also to the speakers that we've heard this evening, clearly expects that the funding of public dollars that go to non-government schools be used only for the purpose of enhancing student outcomes. It does not mean, of course, that a school cannot make a surplus. That's inevitable in a budgeting situation, but just that any surplus must be used only for the operation of the school. Under the government's proposed legislation, that definition of for-profit will be tightened and is welcomed. Our policies state that the Greens will work towards, quote, ensuring the future funding and regulation of private schools does not, A, disadvantage the public school system, B, exacerbate socio-economic inequality, C, create ethnic and religious divisions, D, disadvantage students with special needs, E, permit discriminatory behaviour, or, and this is important for this bill, F, does not contribute to profits of any corporation or other organisations. And this bill helps address that issue. Madam Temporary Speaker, the current legislation also identifies that a school can make payments at above market value to a related party that is also not-for-profit. This exception has led to some uncertainty in implementing the regulations. Section 83C2B removes any doubt by requiring all financial transactions entered into a school be at market value. Sensible, common sense approach. Section 83C2C ensures that no payments are made to directors in connection with their activity as members of the governing body of the school beyond reasonable reimbursement for out-of-pocket expenses. The not-for-profit guidelines will require the school's proprietor to identify the governing body that has delegated authority for the school. Section 83C3 allows the regulations to provide further details of uses of school assets or income that may or may not be considered for profit. This will ensure that we can take steps at a later time to prevent any future financial practices from occurring that seek to circumvent the legislation. These regulations may also enable prohibitions on particular types of entities or legal structures that may be established in the future with the purpose of evading the not-for-profit requirements. Useful, sensible, going to the heart of the problems that were developed by the former government. We support all these inclusions in the Act that strengthen the original provisions. Of course, there are some other issues in there about that the Minister will be able to choose from a graduated suite of options. At the moment, the stick is pretty severe to respond to any infraction by non-government schools. The Minister can seek advice from the new not-for-profit advisory committee as to whether the school is operating for-profit or not-for-profit. There's issues about suspending, reducing or imposing conditions. And there's also the appeal right to the New South Wales Civil Administrative Tribunal, NCAT, the new NCAT, for schools who want to challenge the Minister's determination, which may make for a vastly less costly exercise for both the government and the school than the current system with the school that has been discussed, which is currently in the Supreme Court. Madam Temporary Speaker, I just wanted to conclude on the point. I won't go through the reasons for change. The 2006 Labor government's legislation banning for-profits left those loopholes, and we said there's a particular, well, there's at least one non-government school, we know of at least one, that is involved in the Supreme Court with the government, but there's maybe more who have been rorting these provisions, or alleged to be rorting these provisions. So, Madam Temporary Speaker, the bill fixes a hole that was created many years ago. I trust that while there may be some amendments that we're moving to address some other issues, the heart of the bill is sound, and I'll be supporting it. Thank you.
Thank you.